116649, State of Kansas versus Anthony Brazel.
Good morning. I am Rick Kittle, and I represent Mr. Brazel, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is reserved.
This case comes to this court on Mr. Brazel's petition for review. Mr. Brazel was driving a car which was stopped by police and was subsequently searched. Suspected controlled substances were found in the car, and he was charged with possession of methamphetamine, possession of oxycodone, and other crimes. His convictions were affirmed in the Court of Appeals with one exception. One of the judges, Judge Atchison, would have found that the evidence produced at trial was insufficient to sustain his conviction for unlawful possession of oxycodone. And if I may, I'd like to take up that matter, which was the subject of some disagreement in the Court of Appeals first. When the car in question was searched, police found pills. The evidence produced at trial was from an officer named Tulin, who described the pills as being gray in color, having a marking on them, which I believe was K57. Tulin said that he went to a website called drugs.com, and that the website is one that is used by law enforcement for purposes of identification, I guess. And then, based upon that, he reached the conclusion that the pills in question were oxycodone. And that was basic.
And there was no objection to him stating that opinion.
No.
Is that correct?
That's correct.
And doesn't Judge Atchison's point really go to a lack of foundation? And so why do we look behind the opinion in a sufficiency examination to determine whether or not the foundation was properly laid?
I don't think it goes to foundation. The issue here is whether, based upon the evidence that was produced at trial, you can look at that evidence and determine, even when it's viewed in the light most favorable to the state, can determine that the state has proved that it was oxycodone beyond a reasonable doubt.
The officer offered that opinion. So
He
there
did.
is evidence that it was oxycodone. And in the light most favorable to the state, don't we just accept that at face value?
I recognize that, generally speaking, there is a principle of law that says convictions of even the most serious offenses can be sustained by circumstantial evidence. But I also recognize, and one of the cases that was discussed by the Court of Appeals is this State versus Northrop appeal case that says there are certain factors that need to be considered in proving identity for purposes of controlled substances. And so I think we need to look at those factors because all we have here is circumstantial evidence, and I think that makes this a special situation. Because there was no chemical testing of this drug. Even though the other suspected controlled substances that were found in the car were submitted for chemical testing, for some reason these pills were not. The factors from Northrop are, one, the physical appearance of the substance involved in the transaction, whether the substance had the expected effects of the actual drug when sampled by someone, whether the suspected drug was used in the same manner in which the actual drug would be used, whether a high cash price was paid for the drug, whether it was used as part of a secret transaction, and whether the defendant ever called this suspected drug by a particular name. And if you look at those factors and measure them against the facts of this case, none of them would support a finding that what we actually have here is oxycodone.
Counsel, you've called them factors, and the quote you've got in your brief says, such circumstantial proof may include, and then it lists several things you could do to prove what this item is. So it doesn't seem to me that this is like a list of factors, you consider all of them, and there's only one that's favorable. It's ways you can prove circumstantially something is what it purports to be. and an officer here testified, based on his examination of the pill and a particular item he viewed on the web that was identical with matching numbers, that this was oxycodone.
Well, I'm not, first of all, I guess, yeah, I mean, I'm calling them factors, but I still think those are things that are valid to consider and compare to what the actual evidence was in the instant case. But if you look at the evidence that was produced at trial, I think we're all assuming, I was even assuming, that what the officer did is went to the website and actually saw something, an illustration, a photograph, or read something that convinced him that what he was dealing with here, these pills, were actually oxycodone. But I don't think that's what he testified to. He doesn't give that type of specific information. He basically just says, here's what the pills look like. They had this marking on them. I went to drugs.com. Drugs.com is a website used by law enforcement, and based upon that, I concluded that these pills were oxycodone. But he doesn't actually say what he did on the website.
What if he didn't even talk about the website? What if he just said, my opinion is these are oxy? And no objection, that was it. Wouldn't that be sufficient?
I don't think so, because in this situation, when we're talking about circumstantial evidence and there's case law that sets forth, ways that this can be proved, and this is circumstantial evidence in its entirety, ways that this can be proved, then I think we need to consider more than just because he says it. Now, obviously, it would have been better if defense counsel said, well, what expertise do you have? What did you do on the website? Did you actually make a comparison, or was it something you read? Who maintains this website? Is it reliable? What's the proof that it's reliable?
Those are all foundation questions.
They are. I understand that.
I'm just understanding your argument. Your argument is that the testimony of a law enforcement officer as to the identity of drugs is insufficient as a matter of law.
My argument is that with this particular type of evidence, we're talking about controlled substances here. If you go to the statute books, there is a lengthy list of controlled substances that are separated by category, and they each have an individual chemical fingerprint or chemical identity. And what I'm saying is, in that circumstance, it's not enough to just have a police officer come in and say, I'm of the opinion that this is oxycodone. In the absence of some sort of chemical testing, which is what you would typically do, in fact, what they did in this case with the suspected methamphetamine, in the absence of any other evidence other than the statement of this officer, there needs to be something more. And that's what the Northrop case talks about as circumstantial evidence sufficient to prove, and it deals specifically with controlled substances. In the petition for review, I've pointed out that on its statute books, Kansas prescribed certain acts related to fake controlled substances. And I've also included references in the petition for review that fake opioids is a growing problem. And so those statutes wouldn't exist but for the recognition of the legislature that fake controlled substances is an actual problem requiring criminal law intervention. And that's why I think it's necessary to have something more than simply the statement of an officer when you're talking about a particular item that is only identified by its chemical signature.
What was before, I appreciate the state bears the burden of proof to prove each and every element beyond a reasonable doubt, but what was argued at district court regarding the argument you're making now? Anything along the lines that this just isn't sufficient?
I don't even know
any motion for judgment of a
no.
None of that.
No.
Okay.
And that's why, obviously, that's why I'm raising this as an issue regarding sufficiency of the evidence, because that doesn't need to necessarily be supported by some type of contemporaneous objection at the time of trial.
Right.
Okay. If I may, I'd like to move on to the other issue I have related to the oxycodone, which is I don't think the I'm arguing that the jury instruction on the possession of oxycodone is insufficient for a jury to find unlawful possession of oxycodone. The jury instruction informs the jury that Brazel is charged with unlawful possession of oxycodone. And that's important here because oxycodone is not like methamphetamine or marijuana in Kansas. It can be possessed legally by a person. So the state has obligated itself to prove unlawful possession. But the jury instruction in this case just simply tells the jury that to find him guilty, it has to find that Brazel possessed oxycodone and that he did so on a particular date in Riley County.
Counsel, how do you get around the procedural problem on that issue? Court of Appeals specifically found that that the defendant had invited that error, and in your petition for review, you didn't mention that ruling.
What I would
the Court
argue
of
is,
Appeals. So how do we
I
get-
recognize that. But what I would say is, let's look at the other instructions that were given to the jury and what the state agreed to when it submitted jury instructions. Instruction number 5 says the state has the burden to prove the defendant guilty. The defendant is not required to prove he is not guilty.
Before you go too far, can you address the procedural question of whether there's a waiver for lack of argument in the petition for review? Because I don't want to lose that part of the question, and then you can return to your argument.
I acknowledge you that the law is probably against me on this point with regard to waiver. I'm not disputing that, but what I'm saying, in the situation where you have an instruction which goes directly against what the Court of Appeals is holding and is telling the jury that the defendant has no obligation to prove he's not guilty, then I would argue that it's a unduly harsh application of the rule of law to, on appeal, say that he has some obligation to come forward to prove his innocence or to raise an objection, which essentially would negate instruction 5 given to the jury, because it puts an obligation on him to prove his innocence in the case.
How does the state prove the negative? Because there's not only the possibility he would have had a prescription, he could be licensed, he could be, I mean, there are a variety of ways in which someone can lawfully possess. So why should we conclude the legislature intended that to be an element of the crime versus an affirmative defense that the defendant, who would have the ability to know which of those multiple things had to be brought into the case?
One thing I would argue is that there is statutory law dealing with affirmative defenses, with self-defense, defense of others, defense of property, compulsion, voluntary intoxication, but none of those talk about the situation we're contemplating here, where the defendant would be obligated to prove, hey, I've got a prescription for this. And again, I think that holding him to that standard goes directly against the instructions that were given to the jury, telling the jury that he doesn't have to bring forward any evidence to prove his innocence. I guess, I hope that answers your question, but I think, again, I think it's an unusually harsh application of the rule of law to hold him to a requirement that he needs to come forward with evidence to prove his innocence when the jury was told just the opposite in this case. I see I've run out of time. Unless the court has other questions, I would submit the balance of the case on the pleadings that have been filed with the Court of Appeals and with this court as well.
Thank you, counsel. Mr. Disney?
May it please the court, my name is Barry Disney, appearing for the state. I had a trial last week where we had a bunch of photographs, and there was no dispute that the photographs should come in or that they were relevant. We were trying to get through the trial. I just asked the defense attorney, hey, can I just admit these without foundation? The defense attorney said yes, because it wasn't disputed. Had the defense attorney said, no, I want you to lay a foundation, then I would have done it. In this particular case, the defense or the state asked Officer Tulin, did you look this up? Yes. What was it? It's oxycodone. The defense could have objected. They didn't object. If they would have objected, then the state would have been required to go back and lay some more foundation about how this was proper to use that, what his experience, all those type of things. But the fact was the defense wasn't contesting that. They didn't object. I think the Brazel court, the Court of Appeals had it right. It cited cases and said, this is a foundation issue. This can be taken care of on foundation, and with hearsay and whatnot. So I would hate to have this court come in and establish a law that we that we cannot use the website on the facts given here because it wasn't contested. And I think that's the reason this court should reject that argument.
Is it sufficient proof without actual evidence that this was oxycodone? Most controlled substance cases, at least in my memory, and drug cases have some sort of analysis validating that it actually is the substance that it's purported to be. Even on paraphernalia cases, you will have there's a residue that would indicate that this substance is contained in the pipe or wherever it is. Here, there's not anything like that. There's just this identification of a pill that has a number on it, and it's consistent with the color and the website. Why doesn't a crime like this or a case like this, absent a stipulation, require some testing or some evidence of what the substance is?
For purposes of appeal, in the light most favorable to the state, I think that yes, the evidence is sufficient. And there could be good reason why the defense attorney did not object. You really, in the courtroom, have to pick your battles. And are they going to object to it being oxycodone and then have the prosecution spend the time to lay the proper foundation? And then the jury's looking at the defense attorney and he's saying, well, you objected, you wasted our time, they obviously proved it. So it really comes down to a strategy decision on the defense attorney. Is that a battle I want to fight? And in this case did not choose. So is there enough evidence? Well, in light most favorable to the state, yes. Now, if they would have chose to fight that battle, the state would have had to come in, and I would grant you probably do more to show that it was. But that wasn't a battle that was being fought that day. The other thing is whether there should be an is whether the possession of oxycodone is an affirmative defense, and the defense argument is that oxycodone is an inherently legal substance. We argue that it is an inherently illegal substance and that it can be lawfully possessed with a prescription. And I think that makes it a classic example of what an affirmative defense was. And I would assert, and I think Justice Byrie, maybe it was you who touched upon that, if we find someone with a controlled substance in their car, and we have to prove that they don't have a prescription, I don't even know how we would do that. They could have a prescription from anywhere, and I just don't know how a state would ever prove the negative that he doesn't have a prescription. So I think that the Court of Appeals got this right by saying that this is in essence an affirmative defense that the defendant would have to come in and prove.
What procedurally, remind me, where do affirmative defenses come into the process of a criminal trial?
Self-defense on
Self-defense is a unique animal because there's an immunity statute. But setting that aside, just a traditional affirmative defense. What I'm driving at, typically that isn't even introduced into the process until after a defendant is bound over.
Until they're bound over?
For trial.
Right.
Is that correct general statement?
I think I would agree with that.
And so what troubles me with the state's argument that having a prescription is an affirmative defense is it subjects everyone with a prescription to possess the substance to being bound over to trial. Doesn't it?
You mean that we could charge
Yeah,
anybody?
as opposed to it being an element, the illegal possession being an element that the state has to prove. Do you see the
I see
tension
your
on-
argument. I don't see in reality that is really it is going to occur. I mean, I see.
Well, that's
your
one of
argument.
those trust us type arguments, right?
Well, exactly, but you do that all the time on a battery case. I mean,
Well, that's what I'm driving at. Is this truly an affirmative defense? That's why I framed the question the way I did. There's a good reason why we treat affirmative defenses as something that a defendant can raise at trial.
right.
This strikes me as having somewhat of a different character. If you're a person who lawfully obtains a prescription, should you be subject to prosecution and then be forced at trial to bring forward evidence of your prescription?
I don't really know the answer to that, Justice. I don't. I'm trying to think of an analogous affirmative defense, and I do think self-defense is. We just recently had the immunity statute, but you can't kill someone, as we pointed out in our brief. But there is a affirmative defense of self-defense. So anyone who is claiming self-defense could be charged. So I understand what you're saying, but I don't think that is really the case here. I mean, if you say that we have to prove this is that this is not, if we have to prove the person did not have a prescription, I just don't know how we're ever going to do it. And I know that is maybe not the issue, or I guess it's not. Maybe that's not your concern. But when in a case earlier today, we talked about absurd results, and I just wonder if we can really interpret the statutes in that manner to lead to, because I do think that would just handcuff us to never being able to prove a case. If there's no other questions, that's all I have. Thank you.
Thank you. Mr. Hill?
The Chief Justice asked about how do you prove a negative. And I guess in this case it would be kind of like how the state proves a negative when someone is charged with not having a drug tax stamp. They're typically asked, well, did you see any stamps anywhere on any of the things that you found? The same thing could apply here. Did you find any prescription bottles? Did you ask the defendant when you questioned him, does he have a prescription for this? There are ways that this can be proved by the state. And I think it's significant when you look at the defendant in this case is charged with possession of methamphetamine, but he's charged with unlawful possession of oxycodone. The way that this is charged, the way that the statute defines these crimes, is a tacit recognition that there are circumstances in which oxycodone can be possessed legally. And that makes it incumbent upon the state not just to prove that the defendant possessed oxycodone, but that he did so unlawfully. And again, the way that the instructions were given here puts that entire burden on the state and not at all on the defendant in this case. So what I'm asking here, and I know I haven't addressed the first issue that was raised, what I'm asking is a reversal of conviction. But I'm failing that, I'm asking for a reversal of conviction on the possession of oxycodone without any retrial because the evidence was insufficient to prove it, or in the alternative there, a retrial on that count as well.
Thank you.
Thank you.
Court will take this matter under advisement.